So the preliminary hearing is sort of a strange concept, but it can be really useful for defense attorneys in terms of gathering information and strategy planning for circuit court. When you're charged with a felony, your first hearing is not a trial. It's called a preliminary hearing. It's an evidentiary hearing to determine if there's probable cause for the case to move up to circuit court where felonies are tried. It is a hearing that technically you could win or lose, right? There could be enough evidence to move forward, or there could not be enough evidence to move forward, and the court could find there's not probable cause. However, the prosecution can still bring that case even if you win at preliminary hearing by something called a direct indictment. That's just a fancy way of saying the prosecution can bring the case in circuit court even if they've lost the preliminary hearing in the lower court. It is not really a hearing that is winnable because the prosecution has that end round to get the case up to circuit court. And so we typically use a preliminary hearing as an information gathering tool to try to get witnesses on the record, to be able to cross-examine them, and to be able to gather as much information about the case as we can from the prosecution while not really putting on our own evidence and showing our hand, because that doesn't assist us in any way.